As already indicated, we regard grounds 1, despite Mr. Halliday's well-judged submissions, and 3 as having a real prospect of success, and we accordingly grant permission to appeal on those grounds. We are not so satisfied about that is the case as regards ground 2, but difficulties can arise from separating out grounds which have at least some common background, and we see that as a sufficiently compelling reason in this case for granting permission on ground 2 also. It's not necessary or indeed appropriate for us to say anything more about the merits of those grounds, save to emphasise the obvious, that this is no more than a decision that the appellants should have permission to argue them. As regards grounds 4, we have carefully considered the appellant's skeleton argument and the paragraph 19 statements, briefly supplemented by the succinct oral submissions of Mr. Beale and Mr. Hickman. We have come to the conclusion that there is indeed no real prospect that if the substantive appeal were dismissed, this court would overturn the considered decision of the Divisional Court about the appropriate costs orders. It is, of course, exceptional for an interested party to be allowed their costs in an application for judicial review, but the Divisional Court was well aware of that, and it identified the features of this litigation which justified making the exceptional order that it did. It reasonably took the view that the joint energy administrators for Bulb were centrally involved in the decision-making process under challenge in a completely different way from the involvement of a developer in a planning case, and they could fairly be regarded as respondents in co-respondents in all but name. The same is not true to the same extent of Octopus, but the difference was recognised by the award to them of only 50% of their costs, and it's clear that the Divisional Court had regard also to the extent to which they were and were not involved in the decision under challenge. Cost decisions of this kind are peculiarly the province of the court which had conduct of the proceedings, and in the absence of a frank misdirection, we cannot see any arguable error of law in the Divisional Court's conclusion. We accordingly refuse permission on ground 4. As regards directions, the only direction that it's helpful for us to make at this stage is that there be an estimate of 3 days. It's been identified in discussion that there will be some points which may or may not be contentious about the bundles, and there may need to be directions at any rate about bundle size, but it doesn't make sense for us to deal with them at this stage. It's also been flagged up that the respondent intends, well, is at least considering filing a respondent's notice, taking the point that the proceedings are now academic. The possibility that may occur has been fed into the estimate, but any issues arising from that will be considered if and when they arise. Hopefully there will be none. so far as the costs of today are concerned, costs as between the actual parties should be costs in the appeal. This may seem rather ungracious to Mr. Hickman, who did in the event contribute submissions to the debate, but the fact remains that the JEAs were not directed to appear. They came as a matter of choice, and in those circumstances we would follow the usual course of making no order as to the costs of their attendance. Unless there is anything else with which we should be dealing, or perhaps the other thing to say is somebody better draw the order. I think it better be between you, Mr. Perrotts, Mr. Peel, you draw the order, get it agreed with the other parties, and submit it to the court as soon as possible. Thank you very much.
All rise.